Judge in 1994. She retired in 2015 and now serves as a mediator and arbitrator of complex litigation. And during her judicial tenure, she presided over 132 patent cases, including multiple nationwide cases where she was referred cases by the Judicial Panel on Multi-District Litigation. She handled pharmaceutical patents. She ruled in cases of first impression. And for any of my patent law students out there, we will study this case, Fuji versus Jazz, on the repair versus reconstruction doctrine. But before joining the court, she serves as a law clerk at the U.S. Court of Appeals for the District of Columbia Circuit. She was an assistant United States attorney. She served in various federal agencies, but importantly, she served as the U.S. attorney for the District of New Jersey. She graduated summa cum laude from Tufts University and magna cum laude from Harvard Law School, where she served on the Harvard Law Review. And so I want to ask you to join me in welcoming Judge Hochberg.
Thank you very much for that kind introduction and for putting together a really wonderfully interesting and informative inaugural conference in an area that really needs to be addressed. And I wanted to also thank Judge Michel for his insightful comments. So many of us who have seen this area of law develop are as concerned as he is about the future, and we're hoping that conferences like this and judges like my colleagues here will show that the wisdom of the judiciary in this area can solve most of the problems and that we can keep a strong patent system for the sake of innovators. I'm willing to guess, although I haven't spoken to my colleagues, that many of them have had the same experience that I have of having had patent cases with small inventors who were severely strained financially just to defend themselves and to pursue the enforcement of their patents. And it has been a real eye-opening experience for me, and I'm willing to guess for them as well. I also want to say, before we start, I understand that you, sir, worked with Judge Lynn.
She taught me everything.
She taught you everything. She has laryngitis today, so you may have to step in for her. I understand that happened once before, and you tried a case that she was supposed to try.
That was my first trial.
Well, how do you do?
Great.
I don't know. I see a pattern developing here. She hears that you're around and she gets laryngitis. Anyway, I'm very lucky today. I'm usually in the position of my colleagues here, but having retired, instead I get to be the moderator. So that's pretty nice for me, and it's great to see them all again. They are all friends. Some I've known longer than others. Let me first introduce them. To my immediate right, Honorable Scott Bolick. Scott has been, I should call him Judge Bolick, has been an administrative patent judge since 2007, and he's now one of the vice chief administrative patent judges of the Patent Trial and Appeal Board. For those of you who may not know, during the discussion, we'll probably resort to the vernacular PTAB, which is the way his court has come to be referred to among a lot of lawyers in the trade. Before that, Judge Bolick was a patent attorney with the Department of the Navy. He's also been in private practice with a very eminent patent law firm, and he has served as a judicial law clerk to one of the esteemed members of the Federal Circuit Court. He got his law degree, magna cum laude, from Georgetown, and he also has an undergraduate degree in systems engineering and electrical engineering from the University of Pennsylvania. And so we're really glad to have you here today. I did call Scott in advance to say that some of the questions might be a little bit pointed, but I would do my best not to make them that way. In the middle, as he should be, is our chief judge today. Rodney Gilstrap has had a meteoric career. He's only been on the bench not even 5 years, and he's already the chief judge. He was appointed in 2011 to the Eastern District of Texas as a United States District Judge. He is a pilot judge in the patent pilot program, but I really say he has so many cases, I'm calling him the test pilot judge. Because he's got, I'm told, by no less of a reliable authority than Mark Lemley, that Judge Gilstrap has 19% himself of all open patent cases in the country. Did you know that, Rodney? Yeah. He gets no sleep. He has presided over thousands of patent cases. In fact, he's got a patent jury case going on right now, he tells me. Prior to joining the court, he was a partner in a law firm, and he's also served as a county judge in Texas. He got his JD from Baylor, and he also got his undergraduate degree at Baylor. And to my far right is Judge Barbara Lynn. Lynn and I were appointed the same year, 1999, to the Federal District Court bench, and we were actually in the initial orientation class together and became friends then, and we've stayed friends throughout all the years. For me, it was 15 and a half years, which means it's 15 and a half years for you too, and counting. She is one of the patent pilot judges in the country, and she and I were among the first two to be invited to a Sedona conference about 5 years ago, where we had our eyes opened as we were studying for each of us had 4 panels that we were on about the impact of what was now soon to be enforced, the AIA, what impact that would have on the federal district court. And to say our eyes were open is the understatement. We were really almost in a state of shock when we were done with the prep work, realizing that this really was a sea change coming to the United States district courts, and that most district judges had no idea what was about to start happening to them in these cases. And that is because, as you'll see from my questions, most of you here, I'm sure, are experts and already know that when Congress enacted this law, it made it a parallel process. And while district judges have a lot of experience dealing with administrative courts, it's almost usually under an exhaustion system. And I don't mean patent exhaustion. I mean that the litigants have to exhaust their rights first in the administrative court and then go to the district court in a sort of quasi-appellate type of case. This is very different from that, and it's caused some management issues and a lot of discretionary decisions that district judges have had to make without full knowledge of exactly how it's all going to work out. So it's really been an exceptional challenge for both district judges and for PTAB judges, because Scott's entire court is brand new. And in fact, one of my first questions, Judge Bolick, is how's it going? Is everybody settling in?
Yes, they're settling in, and there are many more of us on the board today than there were a few years ago. We've just crossed the 240 judge threshold. When I joined back in 2007, there were only about 60 judges, so we have now pretty much officially quadrupled in size in just a few years. But people are settling in. There are still a lot of cases coming in. We have, in addition to the AIA trials, we have a sizable number of appeals from patent prosecution that we are working to go down. I'm happy to report the ex parte appeal backlog continues to drop, and it'll be below 22,000 very soon. But the number of AIA trials, we had an initial jump about a year ago. The number of trials was continuing to increase. It's now stayed for about the last year between 150 to 200 per month, and that rate has kind of leveled off. We have about a third of our judges working in the AIA trial area, and about half are working on appeals. The rest have other things that they're working on. There are other areas of jurisdiction.
What's the average docket now for those working in the PTAB trial area?
Right, and the docket can kind of vary. One of the phenomenon that we've seen is what we call case families or related petitions. So some judges are a little more heavily loaded than others because we try to panel related cases with the same judges, at least up to a point before we add new judges into the judges handling the family. But I'd say just about every judge has at least one decision to 2 decisions a month that they're writing, but some have more in the related cases. So they are all keeping very busy.
I know you recently had some rule changes, and I know you don't have time, and I'm not going to ask you to go through them all. One of the issues that's come up a lot is this issue of multiple IPRs against a single patent. You say you put them into families. Has there any thought been given to limiting the same party's ability to file multiple IPRs? Sort of in the patent trade, the lawyers will kind of tell me when the court reporter's not writing that they use it as a way of getting more pages.
Right. We've had some of those where, for example, a one petition might attack a certain number of claims, and then a second petition's filed attacking other claims on the same art. So that, that's one scenario. There are others where they're truly second bite at the apple type petitions, because there's no limit in the statute to how many times somebody can come back and ask for the same thing, but the board has a tool that allows it to consider whether the same arguments or the same prior art were presented before and decide whether we'll consider that petition or not. That's a tool we've been using quite a bit as of late. We have a number of decisions that are informative and posted on our website, and the general message we've been trying to get out is that second bites at the apple are disfavored unless there's some special circumstances where it really makes sense.
All right, so now to my district judge colleagues, I've been reading, it seems, every day as the patent docket navigator squibs come my way, new decisions in the Section 101 area, almost a steady rat-tat-tat of them. Would it be fair to say that that area of the law now has ratcheted up the amount of your time you're spending on patent cases? Judge Gilstrap?
Well, first of all, let me say it's good to be at SMU now that we've had our football game. I thought it was safe to wear my Baylor tie today.
Yes. And Judge Lynn is happy to be at SMU because she was valedictorian of her law school class here.
I know, and I waited till she had laryngitis to make that. Back to 101. It is, at least my experience, it is ramping up. I'm not sure it's finished ramping up. It's certainly an enlarging and larger area than it used to be. In the last 2 weeks, I've had, I think, 2 101 oral arguments presented, and I have 2 or 3 more set as soon as I finish this jury trial. So it's becoming a routine part of daily life at the district court, where heretofore that was not the case. As I say, I don't have any empirical evidence to say this, but my gut feeling is it will still expand some more before it levels off.
Are they coming in as 12B6 motions or Rule 56 motions or 12Cs?
All of the above.
All of the above. I see, Judge Lynn, you're shaking your head, same thing, same experience in your court?
Most of them are coming in as 12B6. I have converted several to Rule 56 motions for summary judgment just because it gives me a broader realm of information to rely on. I got a lot of press about entering a simple little paragraph in my docket control order that said if you're going to file a 101 as a 12B6, you need to make a showing that it doesn't require claim construction. That simply was a way for us to try and put some docket control apparatus in place because we anticipated a big surge of 12B6 101 motions. Some of them we have converted and held over till we finished claim construction. A lot of them we've taken up at the 12B6 stage. So it's an ad hoc process, but the volume is definitely ramping up.
So to all three of you, one of the issues that I've been trying to grapple with myself as I read through the decisions that are coming down is what criteria or standards are being applied to the, whether you call it Section 101 in the district court or unpatentability in Judge Bolick's court, which comes up in your CBM cases. I cannot tell whether traditional 12B6 legal analysis is being applied or to the ones that come in as 12Bs, or whether sometimes they read almost like massive judicial notice inside the brain of a district judge as to what seems inventive or not. How do you make sure that lawyers are rigorous in applying the traditional legal standards as to what's a proper 12B motion, what should be a 56 motion, or indeed a 12C?
Let me, can you hear me, Lisa? Okay, I'm going to try to croak it out. Very confusing. Lawyers are not rigorous about it, and I'm trying to be. Some are 56 motions, some require claim construction, some are pure 12B6. It all depends. It's not consistent.
Do the lawyers understand that the rules, those same rules of civil procedure apply in the patent cases, just like all the other cases?
No.
I'm not sure.
Does anybody,
I think Alice has caused a sea change in our work, but putting it in the right procedural box is challenging for me and for the lawyers. And it's different from the run-of-the-mill case.
how often do you see in connection with these motions a request to have an expert testify on the inventiveness criterion of the second step of Alice, the Alice test?
Never.
Never.
I haven't had that either.
Interesting. Judge Bullock?
Well, our procedures, as you know, are slightly different in that we don't have, 12B motions, but we do have motions on the merit, and I think that, the briefing, it can be, I guess, sometimes difficult for the parties, but our expert testimony comes in by declaration with cross-examination allowed, but usually not live.
Cross-examination allowed at the deposition?
Yes, in
Okay.
deposition, yes.
So how would a lawyer decide how to present an argument that something is not inventive or an inventive application? Yeah, I'm going to withdraw the question. It was an improvidently put
Recently-
question.
You've been a lawyer more recently than I have, so you should answer.
Usually it's the, what I call the as any fool can plainly see argument.
So it's sort of the pornography test.
Kind of, you know it when you see it. We get a lot of that on 101 motions. Sometimes they're more specifics, but from the movement side, it's generally, this is something that existed in mankind since Noah got off the ark, except it's now on a computer, and that's not inventive. We hear that argument a lot. Then, as a pushback, the respondent usually tries to say, no, but this is different, that's different. They try to find some niche there that they can hang inventiveness on. And that's really, from a high level, an overview of the majority of the arguments I get.
How, in this process, or is it, and tell me if it's too soon to tell, are you getting a sense that in this area, the error rate at the Patent Office was fairly high on some of these? Or is this the exception rather than the rule?
I think it's too early to tell. As far as 101 motions coming on the scene and being filed, we're ramping up, as I say. As far as them coming through the system and enough of them coming out the back end to make that kind of a general judgment, I don't think we've had enough time.
There aren't enough cases to know yet.
I might only object to the use of error rate there because, this is case law that came along
Right.
long after those patents were drafted and prosecuted.
Objection sustained.
Well, I agree. I think that's an important point. I think this is different.
Yeah, it is.
And so I don't think it's fair to go back retroactively and be critical of that.
I'm not even sure that those who created the new standards even understood how they are to be applied. I think that's, from my vantage point, one of the challenges that both district judges and APJs have, is trying to figure out from the standard enunciated by the Supreme Court exactly how it's to be applied.
Well, and if you follow up on Judge Michel's very challenging and interesting remarks, this certainly is at odds with certainty and predictability. Nobody saw this coming. I didn't.
I think that's right. Do you all agree? I see a lot of nods of heads. I think everyone agrees with that. And I would echo Judge Michel's comments about certainty being something that the system wants. I've spoken many times around the country, and I've had lawyers come up to me and tell me they wouldn't even mind if judges ruled against them on Markman. They just want certainty. They just want a ruling. And when the Supreme Court turns everything upside down. Sometimes it makes it that much harder, and it creates an unsettled area of law, and we don't have the certainty that we want. We're all hoping, of course, that we will vector back to it. Let me turn for a minute to, since we're talking about the Supreme Court, the Markman process post-Teva, which is now more deferential standard of review to the fact-finding of district judges. Are more parties seeking to introduce expert testimony at Markman?
I've had no significant change in my procedures or the approach of the lawyers to me.
At all? And
No.
Judge Gilstrap the same?
Yeah, my Markman environment has not changed at all, any noticeable way as pre-Teva, post-Teva.
Isn't that interesting? Because everybody thought Teva would be such a watershed, but it really hasn't changed much.
Well, I just worry about whether I need to make findings, but it hasn't had a significant impact. I just have that in my head all the time, and I'm looking for a case where I need to be making specific findings of fact, but most of the time, I don't need to, and I've seen no change in the approach.
You know, if it's a close question, we try to call it a fact question now.
That's my procedure, too.
Good to know, good to know. So it sounds like that the Phillips decision means that realistically, Teva's not having a widespread impact, at least not yet.
You know, when Teva came out, at least my experience was, I know from those that had been on the bench longer than I had, that there were a high reversal rate, there were problems, or at least perceived problems with the Markman process. By the time I got on the bench 4 years ago or so, those had pretty much worked through the system, and then comes Teva, and I kind of think it's the typical pendulum swinging approach that by the time the pendulum swings, the system's kind of leveled out on its own, and really it was a well-working system when I got there pre-Teva, and it continues to be that post-Teva.
Well, we thought we should be affirmed before, and now we think we're more likely to be affirmed.
I certainly hope so. I think that's correct. I think there's been an initial spate of rulings out of the Federal Circuit on this issue, but it hasn't applied to Teva, to Markman hearings that have been done after Teva came down, and most of them applied to fact patterns and findings by district judges that preceded Teva, so there weren't any separations of findings. And some of them have somewhat curious language, but I think, again, I agree with Judge Gilstrap that the pendulum is leveling out, at least in that regard. One other area I've been wondering for some time whether there's any guess or prognostication that the Supreme Court would readdress the clear and convincing burden of proof for such things as obviousness in district court cases, and if not, whether it's fundamentally fair for Congress to have enacted the AIA with a preponderance burden of proof, and for the Supreme Court to keep a clear and convincing burden of proof on the same claim in the same patent done by the same decision by the same patent examiner on the invention by the same inventor. Is there any justification for that continued divergence between the congressional statute and the Supreme Court law?
Well, this is a First Amendment issue that you and Judge Michelle have the right to address. And
Isn't it nice to
we'll
be-
probably punt.
I know, one of the pleasures of being disrobed is that you get your First Amendment rights back again, and it is lovely. A punt by everybody?
Yeah, you know, we got lots of academics here. Academics seem to prognosticate. Judges try not to. At least we're supposed to try not to.
And I see a nod. Judge Bullock, you're going to join.
All I would say is that Congress provided the standard under which we operate, and so we follow the dictates of Congress. And if they want to change it, that's fine. We'll do that.
Well, I don't know that, the question is one or the other of them going to sort of meet, whichever way it is, should the burden be the same. That takes me to, Judge Bullock, this issue of BRI versus Markman. If we're talking about having a system that's at least welcoming to innovators, what I've always had in the back of my mind is there some less expensive way we can nonetheless do our respective jobs as judges? And it always occurred to me that you only needed BRI if there was going to be an amendment. And so I'm wondering if, and I know that the judges voted very early on when the PTEB was created to use the BRI standard rather than Markman, and of course, the Federal Circuit has upheld their right to do so. The question is, if you had that vote again today, would there be an alteration of it? Is there any basis to think there might be another way to approach that issue?
So there are a number of interesting things, I think, in BRI. I would say that, yes, you're right. When we came out with the rules for how to conduct the trials, the way that the rules were signed were that we would use BRI to interpret the claims, and that made sense to us at the Patent Office because that is the way that we have interpreted patent claims in the reissue proceedings, which are looking at already granted patents, reexamination proceedings that are also looking at already granted patents. As you mentioned, the rationale for using it is tied to the ability to amend your claims, and what is felt the BRI does is promote clarity of claims by asking the patent holder to put something in the claim if that's how they mean to limit it, rather than just relying on some sort of disclaimer or other argument, but to actually amend the claim to put the limitation in there so that it's clear to everybody the scope of the claim. That's the main rationale for using it, and it is not used when we have an expired patent. It was also true in reexamination that came before the office, that the office did not use BRI in expired claims that were in reexam. We don't use it when the claim is expired in one of our trials. It also is consistent with the internal workings of the office. If you have the same patent that's under, because we have sometimes within the PTO parallel reissue and reexamination proceedings on the same patent that's in the trial. When the claims come before the board on appeal, it's interpreted under BRI, the same standard that we use in the trial. Now, that's not the same standard that the district courts use, although currently with some of the recent Federal Circuit cases, including the Quozo opinion, it does seem clear that the board is allowed to consider prosecution history. I think some of the differences were the ability to consider prosecution history, and also there's the general dictate that the district courts construe claims narrowly to preserve validity. That's something that's never been part of the office, which was charged with issuing the patents.
So the question is, how many amendments have there been? There have only been a handful, right?
There have only been a handful. There were a number, the last time we counted, and this is a few months ago, there had been about 100 motions to amend. The majority of those were never considered on the merits because the way the amendments work in the AIA trials is very different than they work in any other proceeding at the office, re-exam, reissue. Our trial amendments normally are what we call contingent amendments, so the board only looks at the amendment if the underlying claim it looks like it is unpatentable. If the board's going to find that underlying claim unpatentable, then we look at the proposed substitute claim and then look at the merits of that. So most of the time, the amendments have not been looked at on the merits. There have been, I think, I'm not sure what the exact number is today. It's around 3 or 4 of the motions that were considered on the merits have been, have been found to overcome the art. And what that does is something that's really different about amendments in trial, and I always like to try and make this point, is that this is an adversarial proceeding. There's no patent examiner who is searching the prior art, who's doing an examination of the claim. So if the board finds that that amendment is going to be granted, that claim becomes part of the patent without ever having an examiner look at it. That's unlike any other proceeding at the office. So it is a little bit different in how that works.
So I had a few parallel proceedings where I made a Markman determination and the PTAB made a BRI determination, and they were not materially different. And it would have been good to know that because the parties went through the expense of doing it at both places. So one of the ideas I tossed off to you on our telephone call, and I just want everybody to know I gave him adequate notice to think about this, is whether it would make sense to save parties the money by asking those who filed papers with you to state whether their Markman construction would be the same as the BRI construction, and if not, what it would be, so that they're bound by it later on when we see them in district court and we don't have to waste the judge's time and the party's money doing it a second time.
Yep, and I thought that was an interesting question. It's something that maybe one of the issues is just the judge resources in terms of construing the claims two different ways. The parties are under page limits in their briefs. So at least with the current page limits, I think the parties might complain if they had to put in claim constructions under two different standards. As you say, though, we've had some cases where, because the patent was going to expire during the trial, the boards construed the claim both ways. And frequently, it's turned out there wasn't any difference. In fact, I'm not aware right now of a case where we looked at it under one standard and under the other and decided that there was some material difference. You're right, that would help facilitate things later on. I think the only concern that I might raise is just in terms of the resources. As I mentioned, we're under a good bit of pressure right now to finish, and we're committed to finishing the trials in the statutory time we've been given, and it's a pretty heavy lift now, so even things that are seemingly small tend to add up.
Well, that's a good segue into this whole issue of the process being parallel. And so time saved at one end may be time wasted at the other. And if you looked at the total time and you added it up the way Judge Michel did a few minutes ago, it gets to be a pretty long period of time, is the concern that some have. Let's talk about parallel proceedings. We're now 3 years into IPR proceedings running parallel to district court proceedings. Judge Gilstrap, have you and your court developed a better sense of what criteria you're going to use when deciding whether to grant a stay and for whether the stay should be for CBM cases or IPRs, excuse me, and when not to stay?
Well, we're learning.
You've had a lot of motions now.
We're getting more guidance all the time. I recently had an issue that went up to the circuit where I had two serially filed cases. One had been tried and a verdict received when the alternate or parallel proceeding was instituted and a motion for stay was filed. One had been through Markman, was a month away from trial, but it was a serially filed case. Same process, they then went to the PTAB and then filed a motion to stay. I declined to stay in both cases. One I got affirmed on, one I got reversed on. So I now have some comfort that if we've been through a trial and the jury's returned a verdict, the stay is probably not going to lie, or if you deny it, you're probably not going to get reversed. Prior to that, it may be a different result. We may need some more guidance. So we're seeing every day a little more light, but we're still in the tunnel.
It always struck me as bizarre choice in the statute, and I haven't read the legislative history, I must admit, to make jury verdicts not even final. That always, I mean, that whole series of cases has just always been a head scratcher for me, but that's a story for another day.
May I weigh in on
Yes,
that,
please.
Faith? So I think it's pretty clear now, looking at the statistics, that before institution, we generally deny a stay, and after, we generally grant a stay. That's what the statistics overwhelmingly indicate. Even in the Eastern District, which was stingier than most courts in granting stays.
Agreed.
But there's also, just to go back to the last topic of
To be
over-
fair, I never granted a stay in the District of New Jersey either, so I guess we're the stingiest, or I was the stingy. I mean, I just didn't see a case where I thought it was appropriate.
You can have the title.
I'm not looking for it.
But to go back to the topic of overlap between the district court system and the PTAB, there's overlap in the district court system. I mean, we're always looking for ways to avoid 4 different courts construing the same claims. And that's an inefficiency in our system that is difficult to work around because we don't really have the money to sit as, in effect, our own MDL to resolve the same kind of claims. We kind of patch that together to try to sit jointly, even remotely, to construe claims consistently. But the system could be improved by institutionalizing that.
That's very interesting. I not had a case while I was on the bench where the same patent term was being construed simultaneously by myself and a colleague on my
Well,
own court.
I've mentioned this to some of you before. Judge Rakoff of New York and I made arrangements to sit together for a Markman hearing. I don't know where he found the money to come to Dallas, but he was coming. And we divided up the work. And on Thursday, before the Monday Markman, his case resolved. So my clerk had a very long weekend.
Oh, I'll remind him of that the next time I
I
see him.
remind him all the time.
So have any of the stayed cases, have we kept stats on the stayed cases and how many of them end up coming back to the district court with 1 or more claims still alive?
Well, I think there are statistics on that, but I'll talk about my own experience. I rarely see them again.
Do you know that they're not coming back?
No, I don't know that they're, what do you mean? Do I?
You know that they're complete, that there's no, that they're not just in another court being evaluated, that they're never coming back, or you
Well,
just?
I require routinely that lawyers report to me about the status of the case before the PTAB. But the stats are that in most cases, a number of claims are invalidated, and I'm not seeing most of these cases come back to me after the PTAB.
I'm not either.
Not either? Well, that's good to know. So, I mean, I guess the question is, will that hold up? Because one of the concerns, just so you understand the reason for the question, is one of the concerns I've always had is what happens to the district judge's workload when a case is not fully resolved. In other words, when there are still live claims and live patents that have been stayed and then come back to the district court and then have to be construed in terms of whether there are estoppels that apply and to whom they apply. And that was one of the concerns we always had going forward. And what I hear, at least initially, at the 3-year mark, is not much has come, so far to 2 of you, nothing has come back.
Well, I've been with you when we've expressed this
Yeah,
concern.
it's never come
I've
back.
never had the estoppel issue raised in a case.
Good to know. Let's hope it continues.
Have you, Rodney?
I can't think of one.
Oh, well, excellent. So I was about
That's
to ask.
19% of the cases in America that you just got an answer.
19%, I know. He's a walking statistician's single-man sample.
All right, since you brought that up,
Do you need another law clerk?
we had 3 active patent judges and 2 of them quit. We still got the same number of cases. All got dumped on me.
Does anybody need a job as a law clerk? So one of the, it's an old saw at this point, but one of the features of the America Invents Act that got very little attention in the press is that the provision that some of the money flowing in would be used to give patent pilot judges an extra law clerk got stripped out by Congress. So that for my colleagues that are still toiling away, they're doing it with the same number of law clerks as judges in rural districts that have no patent cases whatsoever, or urban districts. I mean, there are many judges whose dockets are very, very light on patent cases, and some whose dockets are extremely heavy, as my colleagues here and as I was. And there's no difference in the amount of help you get. It's really a shame. So you're saying, well, that's actually some good news, because I was concerned about that being a bulge. So we have a couple minutes left, I see. I wanted to leave some time for questions. David asked me to ask you whether you saw a role for ADR in patent cases as a way of speeding the process along to create greater certainty that would help investment and innovation, which is what this conference is all about. Do you see one? Is there a way to institutionalize it?
I do. I think those that have practiced in front of me are well aware that I have a standing provision that within 30 days of the issuance of my Markman decision, you're required to mediate your dispute. And I believe that within the immediate future past Markman, you're at for probably the first time in the case, a position when you can fairly and reasonably evaluate your pluses and your minuses and your strengths and your weaknesses. And I think by pushing parties to mediate within that 30-day window after the Markman decision's entered, we take advantage of that situation. And I don't have statistics on it. My sense of it is there are not a huge number of cases that immediately settle after Markman. Some do. But I also get a lot of cases that settle pre-trial that I'm convinced would not have settled pre-trial if I hadn't made the mediate post-Markman.
Now, I had the same experience with settlement conferences in general that I held while I was a judge. Well, a lot settled, a lot didn't, but it was absolutely clear to me that a ball got rolling that caused them to settle within a reasonable period of time thereafter. So it's certainly a valuable thing to do. Judge Lynn, in your court?
So I don't have a procedure like that I use in every case, but my experience is that cases either settle right away or they settle at the point that Judge Gilstrap is talking about. And those are the decision points because at that point, risk is more certain. But
Why do people wait so long? It's always been a source of mystery to me. It's as if, there's like almost a head in the sand approach until the sort of
Well,
Damocles is about to drop.
I think they think they're going to win. But I want to mention two issues associated with that. Sometimes when there's a settlement post-Markman, the parties want the court to withdraw the Markman ruling. I'm not comfortable with that. I'm not saying I'll never do it, but I have resisted doing that.
Withdraw it.
Because I think we have an independent interest, not just to serve the private interests of the parties. And so I would be very reluctant to withdraw a substantive court order, but I've been asked to do it.
That's interesting.
The PTAB has invalidated patents after settlement.
Yeah, that was something I was going to ask Judge Bullock about.
And so the parties don't necessarily control the substantive decision-making of either system by their settlement. So that certainly counsels in favor of doing it sooner rather than later.
Oh, it certainly does. I've actually been asked to come in and mediate now on several occasions where there's a parallel proceeding going on, and the goal of the parties is to settle early enough so that they hope that the PTAB will decide in its discretion not to continue to hear the case. And that's happened in all of them so far that I've mediated, although my sample size is very small. Is there a public interest? Can you share the criteria in which you decide, Judge Bullock, which cases you keep after settlement to make a decision on, and which cases you say, okay, it's settled, we'll move on?
Sure, and just for those who weren't aware, in the American Invents Act, it gives the board the authority to continue to go to a final decision even if the parties settled. I think we have only done that in a handful of cases. It's generally where we're weighing the public interest in settlement against the public's interest in resolving the dispute, and we recognize the interest in allowing a settlement to go forward and allowing the parties to settle their dispute. Often something that might influence us in going on to go to a final decision anyway is whether there's a follow-on petition or trial that is underway. So even if we settle this one, there'd be another one on similar claims that we'd have to decide later, and the thought being, let's just decide it now. But it is really the rare case where we've exercise that authority. Often, we have dismissed the case after settlement.
So were you surprised, I'm segueing a bit to my last topic, which is this concern about abuse of the litigation process, which normally has been focused on waves of demand letters done by a select few bad apples, and that sort of thing. Were you surprised by the use of the PTAB process by short sellers?
I'm not sure if you're...
Yeah, I'm talking to you.
Okay, I'm looking down.
As they say in New Jersey, I'm talking to you.
Right, so I guess, I mean, and as you know, we have several cases before us that have been much in the press, so I won't comment on any individual case, but just to say that the American Vets Act is fairly broadly worded, and that's a current issue that is being wrestled with, is when does use arise to the level of abuse. There are cases currently where there are various motions before us that would be decided in due course as to whether the facts in those particular cases have arisen to be abusive. The Congress did give us some tools to deal with abusive filers, and so the question in any case would be, is this one that rises to that level?
What are the criteria?
Well, I mean, this is where they really depends on what happens individually in the case, because we are aware of the potential for patent owner harassment is something that we are on the lookout for. It's hard to say in the abstract what is, what would be an abuse and what wouldn't be. You'd really have to look at what's going on in that particular case. But I mean, something that I think would probably clearly be an abuse if somebody had fabricated evidence to provide as the basis for their petition. I think that's pretty clearly abusive. But it's hard to say, outside of something that's fraudulent, what conduct rises. And as I mentioned, we have some cases now where the panels are being asked to decide those. So.
Yeah,
Stay away from
and he's wisely refraining, just so most of the audience may or may not know, that it was certainly a surprise to me to learn in about April of this year, maybe it was May, that Wall Street short sellers were availing themselves of the fact that there's no standing requirement to file an IPR. To file an IPR, and certainly according to press accounts and discussions I've had with attorneys involved on the defending end of it, who were as shocked and surprised as anyone else, that they would use it, at least the allegation is, use the ability to file an IPR as a way of depressing the stock price. If you're a short seller, it's a brilliant tool. The particular attorney that I learned this from, and it was purely fortuitous that I learned it, said that she was surprised, so she called over to England, where they don't have a standing requirement either, which is to some extent, I think, part of a model for what we are doing here, and asked, how do you handle short sellers? She said abusing. I realize you haven't made that determination yet. Abusing the process. And the answer was simple. In England, they don't allow short selling. So the model around the world fits for some, but not all. Now, I'm not saying that I know that. I'm just reporting on a conversation I had with a patent lawyer in New York City who learned about it at about the time we were both guests at something else, and she told me about it. I was completely taken aback by the thought that yet another vagary had entered into this parallel proceedings land that we are now in. So that brings me to the more generalized topic, and my last topic, which is abuse of the litigation process. I was trying to count up how many, in my own mind, and obviously I don't have my entire docket of any kind available to me anymore, how many true, real abusive trolls I'd run into that I would have considered a troll as a district judge, and I can only think of 2 in 15 years. Are your numbers significantly higher than that, Judge Lynn and Judge Gilstrap? You've got 0. Judge Gilstrap?
Well, you're asking for a characterization, and
Where I found that.
No, where I've felt that. I agree with you. Oh, I certainly would not say that. I certainly do not. I agree with Judge Michelle that not every non-practicing entity is by any means a troll. and then it has to do with what you're doing.
Basically, you're
Rather
asking
than-
where we concluded that.
Where we concluded that someone was just deliberately misusing a patent to collect a buck in an improper way.
Are you talking about a personal conclusion, or are you talking about a formal public?
I'm talking about in my case, I wrote an opinion, it preceded the use of the word troll, so I didn't use the word troll.
You're the one that came up with that term?
No, I did not. No, I didn't call this person a troll. I'm sure I didn't even use a name. I basically dismissed the case, sent him packing. A judge in, I think, either Seattle or one of the districts in the state of Washington sanctioned him. He went to the circuit, appealed my dismissal, and then I of course forgot all about the case, and then when I wanted to know what happened to it a couple of years later, I learned that the appeal was dismissed by him. He voluntarily took a dismissal of the appeal, which was actually, if you're a troll, which is what he was, although that word didn't exist yet, a smart thing to do. You have 2 district judges out of, let's say, 50 who've called you for what you are, and you avoid a federal circuit ruling on it. So you can keep the fact that you've just sort of got a few stray district judges ruling against you, can continue the behavior without having to worry about what the federal circuit's going to say about you.
I can't think of a time that I've said that either from the bench or in writing. I won't comment about what my own personal thoughts are behind the robe as I see cases go before me. I routinely grant orders in limine in anticipation of trial that preclude pejorative terms, and I consider patent troll, patent pirate, all those kind of things pejorative. The other side of the coin is I routinely grant limine orders that prohibit pejorative references to big corporations and the elite and Wall Street raiders and all those kinds of terms too. So I try to keep the pejorativeness out of the process. But I won't comment on what I might personally think about, this party or that party.
No, my question was poorly put.
I may be misunderstanding your question.
Yeah, no. I've never used the word troll either, and in fact, I've routinely spoken out about it, saying, the way it's bandied about it would cover some eminent universities, academics, hospitals, et cetera. So it didn't make sense to me the way it's used. I completely agree with Judge Michelle about that. What I was saying was that a case, in fact, my case, I certainly didn't use the word because it didn't exist yet. I had 1 and perhaps 2 cases where I thought that someone's behavior and the way they were using a patent in the manner in which they were using it would, if brought today, would be the kind of thing that could, I would never use the term, but could be considered improper or abusive litigation tactics. But it's so small, that's the question. I've had very few, as in 1 or possibly 2 out of hundreds of cases.
Let me make one comment. I'm an honorary member of the Eastern District, so I can say this. I think...
Non-dues paying.
Correct. I think lawyers feel like these cases exist, and many of them are filed in the Eastern District just because of the volume, but they're diverted out before Judge
Yeah.
Gilstrap sees them
I see.
because they're so small that people are paying what they regard as extortion to make them go away. I've heard a lot of lawyers say that. I can't speak to that because I haven't seen those cases. I read all my cases and I don't see them in the Northern District, but my volume is so low. So these cases are in part the driver for some of what's going on at Congress in terms of reform when they're an infinitesimally small part of the patent docket.
Agreed. I totally agree.
And I think Judge Lynn hit the nail on the head, at least in my district. I'm not saying that's not there. I'm saying, all I'm saying is a motion to dismiss a party out, and it never gets teed up in front of me where I can make that kind of value judgment, because a petition's filed, a defendant served, and then there's a motion to dismiss. Now, I see lots of serially filed cases, and I see lots of motions to dismiss, but I haven't had it in a in a litigation sense where I have parties in the courtroom making an argument, this is that, this is that, this is an abuse. It's not come before me in a judicial capacity where I would make a conclusion.
No, that's interesting. So have either of you had occasion to enter rulings under Section 285? Have you had motions?
We have lots of motions.
How often,
That's the-
how often are they?
Another item on the checklist, along with 101 now.
Yeah, that's what I was getting to. Is it happening too often? I mean, could you see a 285 motion brought for frivolously bringing a 285 motion?
Haven't seen that yet. I wouldn't say it won't happen.
Nothing is beyond the imagination of the bar.
Is this beginning to happen in every case? I mean, I retired from the bench just about the time this tool was becoming widespread in its use.
I won't say every case, but in cases that actually go to trial and there's a verdict, the number in which the prevailing party is seeking recovery of fees under 285, the percentages there are definitely on the rise, definitely.
Are you, do you find that it's a sufficient tool to curb whatever concerns there might be about improvidently brought patent cases?
Well, you know, I think some of the guidance from the Supreme Court in Octane Fitness is appropriate. It truly has to be exceptional. It truly has to be an abusive situation or an exceptional situation. You know, those of us that grew up in East Texas trying lawsuits for a living, the fact that you lost one doesn't mean that it was an exceptional case. And a lot of lawyers are now thinking, I won, they lost, so ipso facto, it must be an exceptional case. And that argument doesn't get very far with me. That doesn't mean I'm not open to a meritorious argument where there truly is something exceptional that sets that case apart. But it is by its own definition the exception and not the rule. And when you see 285 motion after 285 motion after 285 motion, you look at it and you think they can't all be exceptional. And in truth and practice, very few probably are.
I think that you've probably stated the view of 99 to 100% of the district judges around the country on that. Judge Gilstrap, I think that's pretty much how everyone would feel. And it reminds me of the days not that long ago when we saw the same thing happen with Rule 11.
I will share this anecdote. I got a lot of enjoyment out of this. I had two pending 285 motions in two different cases, and the defendant in one was the plaintiff in the other. And so on Monday, that party argued that this was truly an exceptional case, and on Tuesday, that party argued it was not anywhere close to being an exceptional case. So I got to use the transcript for one to write the opinion for the other, and that was a lot of fun.
That is, well, I want to thank all of you. It's been wonderful and appreciate your candor and your help to the audience on an important topic.